MBAs, people in business school, they take classes in the corporate strategy. They're literally explaining how to do all the things that I say are bad in antitrust class. It's like, how do you differentiate a product? How do you build market power? What Google did in building the tech stack, if it's not the subject of business school case studies, it definitely will be, because it's a masterclass. Unfortunately, they did it in ways that were found to be illegal, but they certainly were very effective and very creative. And Google surely had a technological mastery that allowed it to take a number of moves that were extremely effective in building market power. Every big monopolization case, it's widely reported in the press, this company will be broken up. And I always say to people, you're crazy, don't worry about it, it's not going to happen. I think in this case, it really might happen. WhatsApp could have been a competitive threat to Facebook, because at the time, WhatsApp had 100 million users. Big threat to Facebook, because with 100 million people, maybe you can just become the next Facebook. And so the government's theory, Facebook wasn't trying to ruin WhatsApp, they were trying to keep somebody else from becoming Facebook.
Welcome to the SVIC podcast, where we deliver tech insights without the hype. Join my co-host Joe Ternasky and me, Jordan Thibodeau, as we break down the latest in tech, cut through the hype, and host top industry guests for exclusive insights. Hey everyone, welcome to the SVIC podcast. We are joined today by Chris Sagers, professor of law at Cleveland State University. I messed it up once. I said Ohio State, and Chris corrected me, rightfully so, because it's just like, how dare you? It's like me saying, like, you're a professor at North Carolina, and I'm like, oh, professor at Duke. It's like, you just don't do that, So Chris, good to have you here. Chris also wrote a book on antitrust law. And so we are going to be talking about antitrust because that's currently what is on everyone's mind right now. Give me one quick second. I'm going to show the book. It's called United States versus Apple, Competition in America. So he has written this book, and also Chris was quoted in the Wall Street Journal. Well done for you, Chris. So how are you? How are things?
Doing great. Thanks for having me, as always.
Google and the antitrust case. So maybe I can set this up a bit. So in a landmark decision on April 17th, 2025, U.S. District Judge Leon Brinkema, Brnkema, messed it up, found that Google holds an illegal monopoly in two specific online advertising technologies markets: publishers, ad servers, and ad exchanges. The suit, brought by U.S. Department of Justice alongside 17 state attorneys, accused Google of tying its ad manager and AdX, both contractually and technologically, to crush rivals and lock in dominance. This is according to AP. So that's kind of like just a broad overview. What were your general thoughts on this situation?
Yeah. Well, each time I read, I'm prone to exaggeration as a person. And I like antitrust. I find it super fascinating, even though, I think any serious person who spends much time thinking about this law has to recognize there's a lot of uncertainties, a lot of regrets, a lot of fears that maybe this policy is problematic. Possibly it's more trouble than it's worth, whatever. It's very hard to know whether it does any good, but it's fascinating, and I have hopes for antitrust being a real policy. So every time I read one of these big new opinions, I think, oh my God, this may be the big one. Like this may be. So anyway, so I did definitely have that level of excitement reading this. Partly, I'm sure, just because of my own biases. I lean a little bit in favor of enforcement. I think monopoly is kind of a problem. So, and antitrust is very, very hard for plaintiffs right now. So every win is significant in that sense. With the appropriate grain of salt for my ideological priors, I was excited, and I thought this was big. I'll say this: MBAs, people in business school, they take classes in this topic called corporate strategy. And it's very funny when you're an antitrust professor who didn't go to business school and you first learn what corporate strategy really is. Like when you look at one of the textbooks that are assigned in these courses, you're like, wait a minute. They're literally explaining how to do all the things that I say are bad in antitrust class. It's like, how do you differentiate a product? How do you build market power? And what Google did in building the tech stack, if it's not the subject of business school case studies already, which probably it is, it definitely will be, because it's like a master class. I mean, it's like, this is how you do it. Turns out, unfortunately, they did it in ways that were found to be illegal, but they certainly were very effective and very creative. And Google surely had a technological mastery that allowed it to take a number of moves that were extremely effective in building building market power. So I don't know, a significant development in history to understand, but also a significant step in substantive antitrust law, I think, an important ruling. It's the place of this case in history. I mean, I don't want to go too far over the top in stressing things, but the place of it in history is definitely going to have to be understood along with the other things that have happened to Google in the last couple of years. I mean, Google has now lost 3, if you think about it, and I'll tell you what the third one is. This one probably is the most significant, I think, in terms of, if nothing else, in terms of the remedy that's likely to be imposed. And we'll get into that. But the 3 cases are, there's the Android case, in which a jury found Google to have monopolized the market basically for mobile software distribution. The search case, in which Google was found to have monopolized the market for search. And then this new case. So pretty much all the crown jewels of the Google, the Alphabet revenue model, unless I'm quite mistaken, are now in the crosshairs. And the most interesting thing probably in the end will be to see what kind of remedies are imposed, whether or not the remedies are sort of coordinated with each other. Remedies are going to be imposed by 3 different judges. And then, most interesting, and this is what gives me anxiety, is going to be to watch whether any of the remedies do any good.
Right. Thank you for breaking it all down, and the complexity of all this, and just the uncertainty of, you think, based upon case law and the Sherman Antitrust Acts, you think you have something proven here that is anti-competitive.
Yeah. In terms of criticizing or critique, thinking critically about this opinion, this result, there are 2 ways of looking at it. One is whether Judge Brinkema applied the law correctly. By the way, it's Leonie. This is a woman judge, a long-term veteran, a very well-regarded federal judge, former prosecutor. And I will say, by the way, again, I might be exaggerating this because I'm happy when a plaintiff wins once in a while, but the opinion I think is really good. Mm-hmm. And I was pretty impressed because I don't know that Judge Brinkema has ever decided a big antitrust case before. Most antitrust cases that are litigated are pretty rare. So most federal judges don't do more than 1 or 2 in a whole career. And she gets it, But anyway, there's 2 ways of looking at it from a critical perspective. Did she apply the law correctly? And, assuming she did the law get it right? Like, is the current policy correct? In terms of whether she applied the law correctly, reasonable minds will differ, because part of the decision, part of whether she got it right or wrong is whether she inferred the facts correctly from the evidence that existed. And who can really say whether she did that right or not? But in terms of applying the actual legal rules, it was impeccable. And for what it's worth, this, I presume Google will appeal, but I think this probably gets affirmed because I don't see obvious mistakes in the legal rules. And fact finding from the evidence technically can be reviewed by a court of appeals, but it almost never gets reversed. So what she thinks of the facts probably is going to stick. And I don't see that she applied any of the legal rules incorrectly. And this isn't the kind of case the Supreme Court is likely to take, I think. So this result will stick, and it probably was right. And people in antitrust will probably more or less agree that it was well decided, and more likely than not, people will say it was correctly decided. Whether it's the right policy, no one will ever agree for the next 100 years.
Right. Yeah.
It will be very hard to judge.
Exactly, because it also just depends upon what metrics are you looking at to say if this was correct, and you can debate about that. We're seeing this right now with Trump's tariffs, as no shocker on the show. I used to work in manufacturing, but I'm very anti the way he's doing his policy, very ham-fisted. And you have 15 different reasons why people think he's doing it, but he's not clear. And they all have different metrics of judging what makes sense or not. So that's where the confusion begins. I created some slides and to kind of just outline maybe the technological aspects of what's going on in the case. And feel free to jump in whenever. This is regarding Google's Ad Manager server. It determines where your ads go. It's a tool for website owners to control which ads show up on their site. And then there's Google Ad Exchange, the marketplace for ads that matches sellers' sites with buyers. It's a real-time auction platform where advertisers bid to show you ads. And then, so Google integrated both of these. Now, these are based upon acquisitions. You had Google's DoubleClick acquisition that it did that was approved by the FTC. And then you had Google also, I believe, buying AdMob or something, and then they rebranded them. And so The process flow is publishers use Google's Ad Manager to manage inventory, and then GAM routes the auction primarily through Google AdX, and then advertisers bid in AdX, often winning due to privileged access. Publishers find it difficult to route traffic to non-Google exchanges, leading to reduced competition and as DOJ claims, like innovation. And so, AdSense is, and people who run blogs, like getting into the weeds, they probably heard of AdSense and maybe haven't heard of AdX. AdSense is for small publishers and bloggers. Easy to set up, requires no coding, and pays you per click on impression. And then AdX is for large publishers with higher traffic. It offers more control, higher paying for advertisers, and real-time bidding, but you usually need to be approved or work through a partner. So this is the current flow. A publisher wants to run an ad, goes through Google Ad Manager, and then it goes to Google AdX, and then it connects through there, and then you have your advertiser maybe like bidding for a price or whatnot. Now, here's the DOJ's claims against Google. They said double dipping on both sides of the market. And I think the DOJ is making a case that this leads to added fees. The judge wasn't really hearing this. Any thoughts on the DOJ's claims against Google? I mean, you were talking about how they narrowly defined what they were going after. And I guess gave the judge the ability to find most of what they wanted, find the ruling that aligned with what they're looking for. Any thoughts on how you thought they brought about their claims? Like, you thought they did it pretty good, or things you thought they could clean up?
I mean, it's good.
Yeah.
What I mean, but that's a layperson's, a complete non-technologist's take on whether the government did a good job. And I'd be most interested to hear. I mean, I can only imagine the chorus of engineers in the world who don't think this was good, and it's going to have lots and lots of problems.